Civil Liberties Project, Cruel and Unusual Punishment. Table of Contents. We will be going over the constitutional provisions regarding cruel and unusual punishment, Supreme Court decisions, legislation and executive orders, and how President Bill Clinton, Gerald Ford, and Barack Obama impacted this topic. Constitutional provisions. Cruel and unusual punishment is part of the Bill of Rights, ratified in 1791. The Eighth Amendment states, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments. Today, there are ongoing debates about whether the death penalty, life sentences, solitary confinement, and methods of execution abide by this right. Groups such as the Quakers, founded around the 1650s, emphasized mercy and rehabilitation over punitive measures. They campaigned against harsh punishments and inhumane prison conditions, and seemingly had a great impact leading up to the ratification in 1791. Supreme Court decisions. There were many legal cases that impacted the Eighth Amendment, but some of them are Trop versus Dulles. In 1958, Albert Trop was a soldier who had his citizenship stripped due to a conviction of desertion in World War II. He argued that this violated his Eighth Amendment right, and the Supreme Court ruled in his favor. This impacted the way that we interpret the Eighth Amendment, bringing to light the evolving standards of decency. Robinson versus California. In 1962, John Robinson was arrested for being a drug addict. He argued that this violated his Eighth Amendment right. The Supreme Court ruled in his favor and emphasized that drug addiction was to be treated as a public health issue rather than a criminal one. Gregg versus Georgia. In 1976, Troy Gregg was convicted of murder and robbery and sentenced to death. Gregg claimed that the death penalty itself violated the Eighth Amendment. Supreme Court did not rule in his favor. Their decision reassured the legality of capital punishment. Atkins versus Virginia. In 2002, Darrell Atkins was sentenced to death for his involvement in a murder and robbery. He had an IQ of about 70, and his defense argued that due to his intellectual disability, this would violate the Eighth Amendment. The Supreme Court ruled in his favor, prohibiting the death penalty for individuals who were deemed intellectually disabled. Legislation and executive orders. Presidents cannot overturn or redefine the Eighth Amendment. They can, however, shape how laws are executed. A few significant executive orders or attempts to make a change that impacted the Eighth Amendment came from President Clinton, President Ford, and President Obama. President Bill Clinton signed the Violent Crime Control and Law Enforcement Act of 1994, significantly expanding the number of federal crimes punishable by death. Some opponents of the death penalty argued that these expansions of punishable crimes violated standards of decency and had an impact on the Eighth Amendment. They focused on the risk of executing innocent people and the lack of conclusive evidence. Clinton did also sign legislation for the funding of states to improve their DNA testing capabilities, also in 1994, reducing the risk of executing innocent people. President Gerald Ford. In 1976, the President signed legislation that brought back the death penalty for certain crimes, including treason, espionage, and the assassination of the President. This led to a significant debate over capital punishment in America. This controversial political discussion is still ongoing today, making President Ford's actions very impactful. Although President Barack Obama did not sign major legislation in regards to the Eighth Amendment, he did impact the legal landscape surrounding the Eighth Amendment. He advocated for broader criminal justice reform, including reducing the mandatory minimum sentences for crimes that were nonviolent. Barack Obama's administration took steps to limit the use of solitary confinement and brought up concerns for the psychological harm it could cause, especially in